Okay, this is Section 8, and we have a few things to talk about with respect to contracts to arbitrate and forum selection issues and the like. But we also have to talk a little bit about Rule 23. But I also want to remind you that on Thursday, instead of class, you're going to draft a complaint for injunctive relief. That information is posted online. It's just a simple complaint where you're seeking injunctive relief. Since you're doing remedies, you should be able to do that. Some of you have drafted complaints in the past as part of the class assignment. Now this one seeks injunctive relief, and the fact pattern is there. Pretty straightforward. Don't go crazy. Think about the notice pleading and the requirements of what a complaint is supposed to look like, and submit it so that it be suitable for filing. Also, we discussed last class that your midterm assignment will be to submit all the answers to all the questions, including the draft complaint for injunctive relief, through Section 8. All the questions on the syllabus, including those in Section 8, by the Monday when we return, which will be Monday, March 18th at 11 p.m. No later. Well, I wouldn't be surprised.
You slighted us on 59 minutes.
Okay. What are you saying?
So when do you slighted us on 59 minutes?
I think if I said 12, you'd then say noon, and I think you'd play even more. So we're going to say, okay, we'll say 11:59. Okay, you want those last 59 minutes? I'll give you 11:59 p.m. March 18th.
All right.
Yes.
What's the complaint? Do you want it emailed or do you want it brought in?
You can email it along with your questions the answers to the questions that you're submitting. Okay? Anything else? Yep.
So I think I heard you said it instead of class. So does that mean we're not meeting?
We are not meeting on Thursday. I am traveling to Atlanta and then Boston for a couple different trial competitions. And with any luck, I will get back here despite the blizzard that you'll all be sitting in. But we'll see. So there are worse places, I guess, to be stuck. But I'm a Bostonian at heart anyway, so I hope I don't have to miss that. Who knows? You know, I mean, it looks like It looks like the weather will be certainly uncomfortable at the minimum, and it sounds like, depending on where you guys are coming from, a lot worse. So it sounds like it's a problem, and they don't seem to have a clue as to really what's going on yet. Yeah, because I guess the line is very flexible at this point, so they really don't have a clue. We could get rain, or we could get a foot of snow. So, but I hopefully will not see that in Georgia, right?
That's right.
Anything else? So you understand what the assignments are? So let's talk a little bit about Rule 23 first, and then we'll talk about these contracts to arbitrate and forum selection issues and the like. Rule 23 allows plaintiffs to sue on behalf of not just themselves, but others. And if the case concerns common questions of law or fact, the named plaintiffs can bring that action on behalf of themselves and any other people similarly situated. Class actions tend to be for smaller amounts of money. But that isn't always the case. Sometimes the likelihood is it's a case that wouldn't go forward otherwise, because there's, frankly, oftentimes no incentive for the lawyer to proceed, because the recovery could be relatively modest. Sometimes it ranges from as little as $10, but there are class actions that certainly can range for significantly more. A lot of the tip and wage cases that were brought in Boston and elsewhere at this point were saying, the house was taking too much of the tips, they weren't paying minimum wage, they're not paying overtime wages. Individually, to proceed with those claims, even if they're, say, for $1,000, it's not in the attorney's interest to advance that claim, because on a contingent basis, you're making $300-400. But if there's 100 people at work affected by the same thing, and we institute suit on behalf of the 100, or at least on behalf of a few or one named individual, on behalf of themselves and others similarly situated, then potentially the recovery there is sufficient that attorneys would be interested in proceeding with it on that basis. The big abuse is that some people criticize class actions as being really for the benefit of the attorneys without much benefit to the clients. And based on some settlements that are of more recent vintage, that's a legitimate concern as well, because a lot of times these cases are brought allegedly on behalf of consumers, and while those actions may prevent that type of behavior from happening in the future, the consumer rarely sees a return on that, but the attorneys are being paid in cash. And by that, what I mean is that the consumer may get a coupon, or the consumer may get a rebate off future purchases, but that's more of a marketing effort than a return on what they lost. And that's a significant criticism and a frequent occurrence these days. I saw one this week someone was complaining about, but it was what has been too often the standard lately is the attorneys are taking a few $1 million out, and the defendant gets away with a slap on the wrist, and the consumer gets a coupon or a promise promise by the defendant never to do it again, and that's not necessarily in the consumer's interest. In order to have a class action, I say that the court has to assess it against the 5 whys, because what you must show is that that a group too numerous for joinder have been injured as a result of common questions of law of fact, and that the named representative can adequately and fairly represent the interests of the class, and that their injury is typical of the type of injury that the class members have suffered. So I use a test of what I call the 5 whys. Commonality, numerosity, adequacy, typicality, and after Walmart, you have to add manageability in, because what the Walmart case does is sort of put that one almost in the forefront by saying even if there are some common questions of law of fact, even if it might make some sense on an efficiency basis to proceed collectively, sometimes the class action could be so unwieldy and have so many other different fact-bound issues that it's not manageable to proceed as a class. That's not the most efficient means of proceeding. And it's that that the Supreme Court gave us that has led to some class actions that were previously certified being decertified, and making it a little harder to get the class certified after the Walmart case. And the process, just so we're clear, because someone came to me to look at their exam after Civ Pro and said, well, when does the vote take place on a class action? And there's really no vote, per se, to decide who gets to be the representative of the class action. The way a class action works is Gary or myself or the two of us band together and we say, we're going to sue on behalf of all the people who bought that remedies textbook of yours, and we're suing on behalf of ourselves, who lost $50 each, and all others similarly situated. Well, we don't know at the time the class action is filed and the complaint's filed who the others may be. And so at some point, the court has to make a determination. Is there a group too numerous for joinder? So who are the other potential claimants here? Who are the others that Gary and Derek are representing by bringing this suit, say? Is the group too numerous for joinder? Are there too many people such that they can't all be plaintiffs in one suit? There's no bright line number for that, but the court has to make that assessment. Over the years, I've heard people say, well, and I don't know where it comes from, but someone said, oh, it's got to be 50. I've never given you a number. I don't think anyone else has, but there is no number where you'd say that's the magic number potentially. The group too numerous for joinder And then you've got to decide some specific questions about whether Gary and Derek, their injury is typical of the type of injury suffered by the class, and whether they and their counsel can adequately represent the interests of the class. Because in a class action, we're not going to see all these other people that potentially have claims. We're going to see the representatives. And so a class action has a significant administrative expense to it as well, because at some point we've got to send notice to them. At some point all of that information has to be assembled. If there is a potential settlement, then we're going to have to send out another notice, and they're going to have to decide whether to participate or not. There's some significant administrative expense which has to be borne by the plaintiffs or their counsel in bringing the suit. So that adequacy, that we have to assess falls both on them and the counsel and really their resources. And then the last assessment the court has to make in certifying the class, because that's what they've got to decide. Should we certify this as a class action? It's a big battle because the defendant may not want the class certified. They want to keep the class small. They want to keep the claims smaller. Sometimes, frankly, the defendants want the class certified. They want to get it done with once and forever. If they can settle out shortly, then they're going to bar potentially other plaintiffs down the road. And it may make sense from both a business standpoint as well as a litigation standpoint to not oppose the class certification. But if there are big bucks at stake, and just as there were in the Walmart case for discrimination on the basis of gender with respect to wages and promotions and the like, I mean, that was a potentially billion-dollar class by all the women who were employed by Walmart at one point or other. And Walmart wasn't ready to write out a check with 9 figures on it. And so they opposed and were successful ultimately in getting the order overturned. And so what the Walmart case gave us is this question of manageability. And what they're saying is that, well, it's one thing when you have evidence that shows that the company clearly decided, in essence, that we're going to pay women 65 cents on the dollar, even though they're worth a lot more, because we can. But oftentimes in discrimination cases, you don't have that type of smoking gun evidence. What you have is circumstantial evidence that is likely at trial to be able to prove that there was an intent and the fact that it was done. But the court said that absent such a smoking gun piece of evidence, then each promotion or denial of promotion, each failure to pay the higher wage really turns on a very fact-specific inquiry of each plaintiff, and it's not manageable to certify it as class and then have 50,000 separate little trials on whether there was discrimination. So manageability becomes a factor as to is this really a superior way to proceed? And in a lot of cases, it is. There's clearly that you've been overcharged $10 on your book, every book that you bought from that place, or other cases where there is within it, it's very easy to prove the liability and likely damages. What that really means is, in a contract case, it's much easier to get a class certified. In a tort/personal injury case where the damages are likely to be almost person-specific, it is harder to get the class certified because the argument against is the manageability argument. But if the court certifies the class, allows Gary and Derek to proceed as a class, the notice then goes out to the class. The court can either use what we call an opt-out or opt-in procedure. Either you get a notice that says, if you want to be a member of the class, you must affirmatively send this notice back and become a member. More often now, they're saying, go to www.iwantmine.com and file your proof of claim. Or you can have that was an opt-in procedure, or you can require an opt-out. You will be bound unless you affirmatively take steps to say you will not be a member of the class. So again, that depends on what it is you're interested in achieving, whether you want a bigger class or a smaller class, whether you use the opt-out or opt-in procedure, because most people given a choice, my rule is to do something or nothing will do nothing. And especially in class actions, I assume I'm fairly typical. I get a lot of these notices, and then by the time I read what I have to do in order to claim the 75 cents, I throw it in the trash. I'm supposed to find an invoice or a bill of sale from a flat screen TV I bought 4 years ago, and that's a big one right now. If you haven't seen it, is the flat screen TVs. They've fixed the prices on those 3 or 4 years ago. It's actually a pretty significant period of time. If you bought a flat screen TV, the likelihood is you overpaid because the suppliers in the overseas decided that they would fix the prices on those panels regardless of what manufacturer you bought it from. And if you think about what the cost of some of those items were, we're not talking 75 cents. But I don't know whether you can find your invoices from 4 or 5 years ago. But I can't.
Because I can find it. Wait a minute.
No, seriously, if you Google it, you'll probably find it. TV's already going to answer you. She's going to tell you where to go.
Now, I was going to ask you, if you don't affirmatively opt out, do you get a check if there's a settlement? Do they know you?
Yeah, they're supposed to, unless it says, well, you can opt out. But then sometimes it's you must affirmatively opt out, or if you want to partake, send us the invoice, send us this or that. You know, there's been, with respect to cell phones, the flat screens. The flat screens are the ones I saw recently, which probably affect, anyone who, honestly, I think the ad, one of it said, if you bought a flat screen TV within the last 5 years, and you're thinking, okay, so but you got to come up with the rest of it. So some one of you can find that information, if you can find your bills of sale and the like. Go ahead.
Do you ever open yourself up to liability when you opt in?
Not really. We had a case in first year Civ Pro with that Ford case where they said is that then Ford wanted to bring a counterclaim, and the court ended up decertifying the class because they said that's not what these plaintiffs signed up for when they became members of the class. So I would say no, but my hesitation is with saying never. So I think the correct answer is no. Never. Could I think of an extreme example? We know the Ford Motor case, they tried. So I don't think it's really possible. I don't know what theory it would be. But a case like that, if you remember the case from the textbook, Ford is bringing, the plaintiffs brought suits for discrimination saying they were open. We're surprised that this happens because we have these cases around here as well, that individuals overpaid for in obtaining credit because either their property was in a red line neighborhood, or that they are a minority, or because of predatory lending practices, whatever. We overpaid, and therefore give us money back. And that's what happened in the Ford case. Well, then Ford said, in order to try and chill the class, they said, well, you can certify the class, but a lot of these people owe us money because they ended up not paying the notes, and there was a deficiency at foreclosure, and we have deficiency amounts on the notes that we would like to collect. So, of course, who's going to sign up for a class action where instead of getting a check, I might write a check? And so what ended up happening at the end of the day is the court ended up decertifying the class. So I don't want to say never, because there could be a situation where you would see, think about some of these predatory lending cases with around here and elsewhere, where my guess is, if you're representing the Countrywide Mortgage or whoever it might be, you're going to argue that not only shouldn't they get money, they owe money because there's a deficiency on the note. And I assume you would all do that if you're representing the defendant Countrywide. It's not just, well, we'll just write out a check. It's the best defense is a good offense. So we would potentially assert those claims. And I don't think there's anything illegitimate about that. We assert counterclaims all the time. The best defense is a good offense. If the plaintiff has nothing to risk losing, then they can go forward with impunity. If, on the other hand, a counterclaim is advanced, that can be advanced consistent with Rule 11, it should be advanced, because that changes the dynamic of whether to settle or go forward. And if you go forward, you're welcome to, but there's a risk. Again, assuming that you've got a colorable counterclaim that you can advance. It's not just done all the time. I think it's You're required to advance that on behalf of your client. It's not, unless it's completely manufactured, obviously. Okay? Questions on class actions? You see them more and more for bigger claims, but I do think that that's not in the interest of your client. If you've got someone seriously injured because the Jeep they bought from Chrysler rolled over, and so they're paralyzed, and you find out that the Jeep, Chrysler knew it and continued to sell them, and you now obviously you know that there's not plenty of people drive Jeeps, so there's other people like this. From the standpoint of your client, the one that you're representing that's paralyzed, there's no incentive for them to be a member of the class. The incentive for them is to get out in front and run with it hard by you as their lawyer, because maybe Jeep will pay a little more to keep it quiet. I mean, those were the exploding Ford Explorer tires. At first, they paid a premium because you guys all are willing to bury the evidence and keep quiet. On the other hand, though, for the lawyer, so now I've got a case where I have a person who could be the class representative in a rollover Jeep cases that I'm the first one to discover and advance that suit. And I do a little investigation on Google and elsewhere, and I find already I can see hundreds of these cases where many of them have resulted in paralysis. Wow, that's a big class. That's a retirement class action for you. It is, right? But I don't think it serves your client's interest, because now they're stuck in the pool, and obviously if the damages get big enough, the company might just go belly up. You're going to be okay probably because you can spread out all your damages with all your different plaintiffs. But I don't think the individual plaintiff that you first started with under those circumstances is well represented by a class action. They are not.
So in that case, even if there's a class action against, say, a particular, like for instance, I have one opened up right now. I just got this in February. It's from Facebook. It's they're suing Facebook, and everyone could get $10 if you.
That sounds like a scam, you know.
You think it is?
Yeah.
But it's just like.
All you got to do is give them your bank account number and social security information.
Hey, you have an account with everybody. But
I'd be careful.
Yeah, I didn't go through with it. I was
Okay.
just reading it, and one of the options is you could exclude yourself. So is that saying, I think I should get more money for this? I want to.
Yeah, but see, that's the problem. Sometimes, I'm going to exclude myself. It's a lousy deal. I'm not gonna take part in it. So you're gonna sue for the $100? You're gonna take 10, or you're gonna sue for the 100? You're gonna sue for 200, 300, 400?
What is the issue? Why are they even sending that out?
Because
Privacy.
Facebook sold like images, statuses, and stuff to use for advertising purposes, and so now people are claiming that they didn't have the right to do so.
I mean,
But it was to the company they acquired, right?
You're part of
So
Facebook,
the
you
company
don't
they
have
acquired,
privacy.
they shared with, I think. That's complicated.
Yeah.
I got one from AOL too recently. I saw a little postcard from AOL. I don't know what that means.
Well, listen, actually, virtually every other week, there's something either in Parade or one of the magazines which is talking about it. They're very lucrative for us, extraordinarily lucrative for attorneys. There tends to be a specialized plaintiff's class bar that tends to work it because they do require a certain level of administrative skill in addition to the political skill of working with so many other attorneys that are involved in the suit. But obviously, the lawyers have a tendency to make a fair amount of money through these cases. And in some cases, it really makes sense. I had someone come see me one time. It was clear that he should have been paid overtime. They weren't. They were requiring other things of the employees and not paying them at all for the activities. And if you look at the wage statute, there's no doubt that they owe them money for these activities. Over 3 years, what's it likely to be? $1,500. So $500. I got to, and I don't mean to sound, but I'm going to do all this work, and I'm going to end up at best $500 for it. That just doesn't, maybe there's someone out there, maybe you can bring it to small claims, right? I mean, there are other advice I can give you, but I'm not going to do it for that. But again, And let's run the numbers. How many employees work at this company? How big a company is it? Again, well, if we look at one of the big box retailers and it's one of them, well, this has some real appeal to it. A large, potentially nationwide company that has practices like that makes sense. This is what Shannon Liss-Riordan did in Boston with the tip cases and the like, is that for individual bartenders and waitstaff, it wasn't worth it to proceed. Collectively, it made sense. She made enough money and she bought one of the companies. So it can work that way, and it is beneficial in certain cases when it's not abused. Let's do our contracts to arbitrate, mediate, form selection issues. The first one there is Carnival Cruise Lines versus Shoot. And some of you read this when we did Civ Pro, but I like this case because I think it's a great example of a forum selection clause that almost couldn't be more onerous on the plaintiffs, because they're from Washington State. The cruise leaves from somewhere in Southern California. The accident happens off the coast of Mexico on that cruise. But there's a clause in the ticket that says if anything happens, they have to bring their suit to Florida. And at the end of the day, the court says, yep, that's right. Because they knew about it before they went on the ship. Having known about it, in essence, they accepted the term, and therefore they're stuck with Florida, even though the only relationship Florida bears to this transaction is that happens to be the home court of Carnival Cruise Lines. And so what does that mean for all of those agreements you guys are clicking through online? Right? I accept. Because you probably all bought things through eBay or PayPal, Apple, whoever.
You're going to be bound to their form.
Wherever it is.
That actually means I accept the
I accept means you accept, even if you don't bother to read. But, well, that's shame on us. And by the way, you're all upper-level law students, so we sort of understand. If we don't read it, that really probably is shame on us. Everyone else supposed to have that understanding when they're buying something on PayPal or eBay or Apple or whoever, that's the way it works, or if they're not smart enough to read it. By the way, if you ever do say, well, let me see all those things, right? Because I think I printed off eBay's one time, and it's about yay thick. And they all are like that. I mean, I assume that you, as the lawyers, wrote those. No, right? That's what we do, right? Because if I'm online selling stuff, the alternative potentially is I could be dragged into every state in the United States, right? And I can't afford to do that. All you little clowns bringing me to small claims court every podunk place across the country. The hell, how can I run my business like that? So this is just a provision that means companies can do business in the modern business world. And if you don't like it, don't click I accept. Shoots didn't have to go on the cruise. You don't have to buy something online.
I think the difference there, though, the Shoots, they don't learn about the forum selection clause until after they physically have paid for and have the tickets in hand, whereas an online purchase, you do actually get to read that.
I agree with you. So what that means, though, is that when you click I accept, it's even worse, right? Because we're not even going to save the Shoots here, right? The Shoots don't even get that provision till they've already paid for the non-refundable ticket, and the court says, that's okay, right? And I do think, by the way, to some extent, they save it by saying, okay, we paid for the ticket, we read it, and then we stepped on the ship. Because I do think they would have a stronger argument to say, we paid for the ticket, we got the ticket, we read it and said, oh no, now I want my money back. Could they then arguably sue them in Washington State And I think they'd have a strong argument and maybe be successful under those circumstances, because I can't accept it if I'm not offered the opportunity to be aware of it. And so I think that might be a different situation. I think their problem here is, but the point, the original point we started with, if the chutes can't get any relief, when you click I accept, you're certainly not going to get any relief. So I can have a forum clause like this. Choice of law clause, I assume, as well, because there's a whole bunch of different laws that states that might be involved in the transaction. And we can even agree that you won't go to court at all.
Sure.
No, it's okay. Go ahead. Why not? If you can agree to a forum, and if you agree to a law, why can't we agree to no court, no forum, but Ash's arbitration service?
Well, arbitration is one thing depending on the nature of the beast, but the biggest argument in the Carnival case, I think, was the fact that Carnival is keeping its prices, or business keeps its prices lower.
Do you really believe that? You really believe, we could raise our tickets and we can make the chutes come to Florida. So, I heard the court, I read where the court said that, well, this keeps the cost of cruises low. Is that true, by the way? Because I don't cruise because I get seasick. Cruises don't cost very much?
It depends on if you get a package.
Huh?
It depends on if you get a package and how many days you're going for. So if you're doing a little weekend, little 3-day cruise, you're returning on the 3rd day, that could cost you maybe, depending on what side of the ocean or
Like
what
50,
you get
75 bucks?
No, about 150 or so.
Really?
$200.
No, seriously, that little for a 3-day cruise?
But then when you go to the 7 days, and it also depends on where you're
That
going.
doesn't sound right. I can do a cruise for $150 for 3 days?
Let me find.
Yeah, you find that. Yes, is that true? Really?
Fraternity cruises.
Huh?
It's true. It's $200.
Really?
I had booked an Alaska cruise last year. It was like $500 for the week, but the airfare would encroach it.
Wow.
You gotta-
Right, it's the airfare. Yeah, it's the airfare.
So they are actually keeping their prices cheap by limiting your rights to sue when you get hurt.
Well, imagine if.
And they didn't limit the right to sue. They said she could sue.
By not repairing their ships.
Not repairing the ships, not having backups for their essential services. Putting 12 bodies in that room of Kelly's that she's getting for the $1.50 for the weekend.
Woo!
Well, imagine if 10 or 15 passengers slip and fell. I mean, this is a way to protect the company. I mean, how are they going to settle cases all around the country?
And that is their law. That is their argument, right? I mean, one argument, the counter could be, well, you could make your ship safer, because there's very little incentive to take what might be otherwise very dangerous conditions and eliminate them, because there's limitations of liability. But I think, go ahead.
Well, couldn't they just hire a lawyer in Florida? They don't have to appear themselves, don't they?
Well, if there's going to be discovery, they likely will have to appear. That's something we don't always think about. But the fact is, if they're the plaintiff in Florida, yes, they would need Florida counsel to file the complaint. But then that really means is that discovery is going to take place in that forum as well. So if I were Carnival Cruise Lines, after I asked them for documents, I'd mark up their deposition and make them come to Florida, because that's what they have to do. They're the plaintiff. They have to cooperate with the discovery process, and their failure to do so means I could move to dismiss the claims under Rule 37 as a sanction for not complying. So I'm going to drag them back and forth to the extent I can. That sounds terrible. Lawfully, so that
You can inconvene them.
But
so that at some point they say, I can't afford this.
But they could fight that too, I would assume, right? Like,
I don't know how a plaintiff could fight a deposition.
They could say one visit, you gotta hit.
Oh, right. They could argue that we'll come once and you get one shot.
You have 8 hours or something. Isn't there a limit?
There can be limits imposed on how long the discovery is. So yes,
7-day cruise out of Boston, $6.99.
yeah, $6.99. You said $1.50 for 3 days
For
is what
3
I heard.
days, but that's for 7 days, and that's out of Boston, and it's going to what?
Well, 7 days for 700. Correct me if I'm wrong, but that would mean 3 days for
That's Royal
300.
Caribbean. Let's try. You confirmed 200.
They already confirmed you should have quit while you were ahead. They said you weren't crazy, so you should have quit while you were ahead.
I'm gonna
but yes, you can try and help them to restrict the abuse of the discovery process like that by saying, we'll come, listen, I do that around here. The plaintiffs, we'll come once, we'll stay as long as you need, but we're doing it once. Because I don't want them to have the transcript then after the first day, bring us back a second now, just jerk us around, have the answer, start impeaching us with what they've already got, then asking for more documents and coming back a third. I mean, the beat you down process of discovery is real in civil suits. And so you've got to guard against that. So yeah, you could try, but they're making one trip for discovery, no doubt about it. And so, again, maybe you can try and work that so that it's economical and keep it to one trip.
And if it doesn't settle, we'll have to get on the witness stand. Or if they,
Well, correct.
they'll have
Right.
to.
Yeah, they'll have to. I don't see how they could avoid
Civil.
testifying in this civil case. So, right, it's still at least 2 trips in all likelihood. Talks about exculpatory clauses in passenger tickets have been around for a long time. These clauses are typically the product of disparate bargaining power, no doubt, between the carrier and the passenger, and they undermine the strong public interest in deterring negligent conduct. But you know, the more recent trend is that even these clauses can be enforced that place limitations on liability. I told you that when I was doing the bar review information for the students who took the bar last week, that there's a recent Mass case from the Supreme Court that says we can even consent by way of contract to a limitation period less than the 6-year limitation period under Massachusetts contract law. So the fact is we can limit when and what you can potentially do. And you guys know liquidated damages provisions quite often are used in order to limit the amount of exposure in contract cases as well. This federal judge with a radical past goes mainstream. Judge Gertner has retired at this point. She was a federal judge, and what I wanted to bring up with this, because this is her Guinness Harp case. No, it wasn't. It was the next case, the discrimination case. But what I want to start you to think about is when we try a case in federal court, sometimes when we try a case in state court, but not as often, you don't have as much advance notice. In federal court, your case is assigned to that judge from the time you file your complaint. So you know who the judge is going to be for the duration of that case. Wait a minute. Well, 3 nights in Newark if anyone wants to go. Sorry, Gigi. You know, one of the best restaurants I ever eaten in was in Newark. It was, I'm telling you, it was great. It was a Portuguese restaurant, I think. What?
Iberia?
Yes, Iberia. It was excellent. Excellent. Great night. Okay, so now you've interrupted the flow there. So federal court, your case is assigned to a federal judge from the outset. You need to know what that judge is like. You need to know what that judge's leanings are. You need to look. You have a significant advantage over when I left law school because you can get all the information on that judge's, not just their background, but decisions from Westlaw and Lexis like that. And frankly, there's no excuse not to do that, right? We have books downstairs called the Almanacs of the Federal Judiciary. We have some similar documents for the state judges, but not as much, where they will give you the complete background of the judge. And you shouldn't be trying a case, any case, without knowing what that judge's leanings are. And through Westlaw and Lexis, you can get the same information on the judge in the state court, what their prior decisions are. You need to look at that. How do they treat discovery? How do they treat trial? How do they treat summary judgment? Maybe I should go, maybe I shouldn't. You know, and what arguments are receptive in cases like mine in the past? You've got to preach to the audience that you've got. Right? You don't just use a blanket argument. I've got to think about what has reached this person in the past and what will reach them this time. Sometimes maybe I got to look and say, oh, geez, I'm in trouble here with this judge because this judge favors summary judgment and I need to get to trial. But it also tells you then maybe I got to be more realistic about that lower number the defendant's offering at the outset because I may not get to where I need to get to. So all of that is vital information, and I think the reason I wanted you to see Judge Gertner's information is because she really is an exception. Most federal judges do not come with a radical past like hers, and most federal judges, actually I don't know what the number is. The last time I looked at it, most federal judges also are not women. They're a lot of old white guys as a general matter. I remember when we had the ABA case, I think the three judges that dealt with that case in one way or the other were a total of, they were over 200 years old. And you know, with the expectation that someone who is owes their position to the established authority could somehow take a step back from that, probably not realistic. A judge like Judge Gertner or Reggie Lindsay used to be in federal court here in Boston, who comes from a very, very different background. That matters, and you've got to start to think about that and use that to your advantage, and also know how that affects your potential settlement of the matter or not. Guinness Harp versus Schlitz. The question was about terminating the dealership, and there was an arbitration provision here, but the question really comes down to, can we go to court to maintain the status quo during the pending, or prior to the pending arbitration, or does the arbitration clause mean just that? Whatever the dispute is, has to be handled by the arbitrator, and it cannot go before the court at all, because we've agreed that arbitration will resolve our contract. And that's why I think this is an important case, because it does say, well, just because you agree to arbitrate doesn't mean that you shouldn't be allowed to go get an injunction to maintain the status quo pending that arbitration. And so it's a good case for those of us that still want to have some ability to go to court, even if it's just to maintain the party status at their last place before there was any issue that arose, so that the court can in fact allow the legal process, even if it is arbitration, to go forward on that basis. And that's what ultimately the court did here, is it says the federal court is entitled to adjudicate issues relating to the making and performance of the agreement to arbitrate. The likelihood is they're going to enforce that agreement to arbitrate, but the fact is that at the same time they can also allow the case to be held in abeyance, or the termination to be held in abeyance, pending that process. The next case is the Rosenberg case versus Merrill Lynch, and this is Judge Gertner's case, and I really think this is the point I was trying to make for the plaintiff. The plaintiffs are extraordinarily lucky that their case landed before a judge who is more than willing to go out of her way to try and give the plaintiffs their day in court, even though they all signed forced arbitration provisions. And what's interesting about this case is, and this was a number of years ago now, whenever we talk about class actions, we usually talk about relatively small amounts. And one of the students came up to me afterwards and said, I was a stockbroker, an older woman. I was a stockbroker for many years and was involved in this class action with Merrill Lynch. And she said, I got a real big check. And she's tens of thousands of dollars. So sometimes class actions are not just 10 or 15 bucks, but I'm sure that they owed her that money. But this individual claims, and I think that was a pay and wage case, where this one is sexual harassment. They've got an arbitration provision. Why shouldn't they be bound to arbitration? I mean, what's the year of this? 1997, right? So, it's not Mad Men. Shouldn't they, why shouldn't the women be bound by the contracts they sign? What are they saying?
Well, it's almost like the judge contorted and pushed and said that the ADEA,
Age Discrimination in Employment Act.
yeah, Title VII, is in what Congress's intent was, and she interpreted all those things and said, in that case, we can go outside the arbitration. So, I didn't like the case, obviously. I didn't like the ruling, for sure.
Well, let me ask you this. I'm not surprised by either. But let me ask you this. What if they could show, because this is their argument to the judges, what if we could show that this process is really rigged against the females? It's a male-dominated process, and and the men win. How at the end of the day, if we could show that, how at the end of the day is that fair to say we're relegated to this unfair process?
Well,
Even if it was voluntary that we agreed to be bound by it. Go ahead.
I mean, it gets into that two different questions, really, because, I mean, is it harder or easier to prove, well, not conspiracy, but as a general rule, the company does this? Is that going to be harder or easier statistically or however to prove your case, or is it an individual case? So that goes back to what you were talking about earlier. But here, it's like, I think the judge is trying to give the plaintiff here both sides. She was trying to line this case up perfect for the plaintiff, and obviously was definitely against the defendant here. And that's where I think it gets a little unfair, where she contorts the law, she contorts case law, particularly in Congress's intent. So, if Congress writes a statute, she's supposed to go by the law. She's not supposed to be an activist judge who interprets and squeezes and pulls, which is what she does here, I think.
Well, what if the plaintiffs are right? Should the judge try to ensure that the plaintiffs have opportunities for justice?
Within limits of setting precedent, because if this particular plaintiff is right, we split it off and make sure it's not a class action. We tell them to take it themselves and given their facts, and then fine, we fight it out. But if you're going to contort the law, the way it's written, as Congress's intent, then you're setting precedent down the road for the, or she's going to get overturned by a higher court, which is what she was trying to protect herself from.
Mm-hmm.
She was definitely writing to her argument, and she was pulling every conceivable. It looked like something I would write last year, trying to convince somebody of a losing case. You know, it's just she's trying to pull every case, it's a losing case, but she's trying to. That's what I saw.
Well, let me ask you about this. I like this language. In my book, it's at 198. And it says, some scholars have even suggested that race and gender discrimination are in fact different from other forms of discrimination, necessitating different procedures and standards. And she then cites, looks like a law review article, arguing that the distinct bases of discrimination and the different procedures in each suggest that Congress intended to fight race and sex discrimination more vigorously than age discrimination. What about that? Because that sounds, I like that language. But that's her stretch? She's got to go find some law review article instead of a case that indicates that?
Congress would have separated that in the statute. That's the thing. If they put all those things in that whole statute, which they did, which I thought was a little overreach, but I mean, they would separate it out. They would say race and sex is here and age is here, right?
Well, are they all the same? Discrimination's discrimination. Doesn't
If an
make a
old
difference
person's-
whether it's age, race, gender, sexual preference. It's all the same.
If you
That's-
lose your job for any reason, you're gonna think it's the same, right? You're-
Well, but are they all the same? I mean, or do race and gender discrimination?
They have a different test.
Well, they have a different test, and they're also, are they worse? Are they worse? Are they more damaging than age or the rest of it? Or because Gary's point is she's carving out two areas here, and he sees it as a stretch to try and distinguish this from ADEA. Or is it different? Because she's trying to run away from the precedent, isn't she? In part, that's his point.
Making it, she's trying to, she could.
Huh?
She could potentially make it precedent. That's the problem I have with it, big time.
But what does it matter whether she's potentially right or not? The plaintiff saying this is a rigged process. We can't win at this table.
But that's the beauty of the law. If you're right, you still gotta prove it. You know, like, otherwise, we're not rule of law anymore, you know?
Well, but is it appropriate for me to be able to waive my rights to court with, and I assume that's with the expectation of a fair process somewhere, and then not have some opportunity to show process isn't fair? If we look at the results here, we're going to find that this is just a game. We're not going to get due process. We're not going to get justice. We're going to get heard and then denied any rights. Or is that just the plaintiff manufacturing a reason why she shouldn't have to arbitrate that she already agreed to? Because, okay, so if this is the way out, I'll argue now that the process isn't fair. That somehow the process is going to discriminate against me.
But that's assuming that arbitration isn't fair. So the burden should be on the plaintiff to prove that arbitration would not work. And why wouldn't it work just as good as a court? So that's where the burden should lie, right?
Well, but she says that the affidavit suggests that there is a good faith basis for the claim that there was a lack of knowing and voluntary waiver, at least sufficient to merit further discovery.
But
Is that all I gotta
case-
say?
But even if that's the case, if she wasn't aware that she was signing that, then if there's still, the burden should be on her to say arbitration is still not fair. Are you really waiving a right? Why isn't arbitration just as good? You know, the arbiters are supposed to be qualified individuals, right?
Right?
So she should be able to get in there and argue her case in front of an arbiter and be just as successful. What she wants to do here, obviously, is get a bunch of jury people pick the way she wants, I guess, or something. You know?
Well, we'd all like that. We all want that,
Sure.
right? We all want the jury that agrees with us.
So she wants more than just to get rid of the arbitration. She wants to be in a place where, you know, she can.
Well, but every
Like
plaintiff
the
wants that,
system.
though, Gary, right? Okay, I mean, so every plaintiff wants a jury that's going to find for them. We don't want justice. We do. No, I'm not here we go. You don't, do you?
We want a good place.
Oh, you know what? Ash looks like a really fair juror, or Sunshine looks like my girl. I'm going with Sunshine, aren't I? I don't want the fair juror. I want someone who's going to agree with me. That's what you've told me this a million times. This can't be even an open issue anymore, right? Right?
You want someone.
So when I'm picking a jury, I don't look to real fair, real good. Real good wins every time, right? That's the way it works. Real good beats fair. That's the way it is. So I mean, I'm not sure it's fair to blame her saying, "Well, she wants to win." Well, we all want to win. Is she manufacturing the claim that she didn't knowingly and voluntarily waive her rights here simply to try and circumvent what's pretty established law, that if you sign off, if you put your signature on these provisions as a general matter, you're going to be bound by them. I mean, this isn't, Circuit City is the next step. I'm going to tell you about my 16-year-old son who came back from Circuit City one summer with their agreement, and it was this thick, waiving, God knows, virtually everything. but this is an experienced business person, right? I mean, she worked for Merrill Lynch,
She's 45 years old.
and she had no clue what was going on. But Judge Gerdner says, well, we're going to give her a chance to discover what she wants, to see if there is in fact an intelligent, voluntary, and knowing waiver. I think it goes back to what I said at the outset. I think she's very fortunate to have a judge that thinks differently, and you need to know that. You need to know whether I've got who do I have sitting up there that's going to be deciding these important issues, and to not do that research to know whether you're holding a good hand or the losing hand, I think that's malpractice. You know, and when I tell you we don't have as much control in the state, is that if your case is going to trial in Superior Court, the judge that might hear discovery motions isn't going to be there to hear summary judgment. The judge that hears the summary judgment motion isn't necessarily going to be there for trial, because they rotate either every month or every few months. They rotate around, and so frankly, well, Judge, when are you going to be back? Right? I mean, if you, Judge, let's set it down for a trial date. When are you going to be back? If I think I've got a judge that I want to try to, when are you going to be back, Judge? You already know it. I can spend a little less time educating the person, but Ash knows he doesn't want that judge. You know, June. Okay, set it down for June trial date. Ash says, oh, I can't do it in June. I'm sorry. July? Right? I mean, that's the way in Superior Court, the process is manipulated a little bit, because I want this judge, who's not necessarily going to be there forever, but he doesn't want the judge I want. He likely wants someone else that comes with a different set of understanding, because at the end of the day, that's the judge that's going to be admitting the evidence. It's not the judge necessarily, not the judge that's going to be finding the facts, because that's going to be the jury. But he's going to be the judge it's going to be the judge admitting evidence and instructing the jury on what the law is. And that matters, depending on what perspective you bring to the table. And so you guys got to think about that. I think Gary's more right on that than usual. Because I think that plaintiffs are very fortunate that they've got a judge who went out of her way in that case, and as a general matter went out of her way to hear both sides. Oftentimes, she wasn't just straight left wing, but you do not see most. I'm not sure there's another federal judge in the country that has her background. You know, I mean, she represented real radicals at one point, and that's not the person that oftentimes becomes a federal judge. Let's see.
You know if Merrill Lynch could have done anything in this case to try to get a different judge? Probably not. Obviously
Well,
not.
wait a
They
minute.
must have tried.
Okay, well, wait a minute. What do you mean she must have tried? Okay, so listen, you got the short straw. Okay, you got the judge you don't like, unless you can show she's biased. And listen, here's the whole problem with that process. What a bunch of hooey that is. If you want to disqualify a judge, and virtually anywhere, but in federal court the rule is clear. If you want to disqualify the federal court judge, the motion goes to that federal court judge, who rules on whether they in fact are biased and get disqualified. And more often than not, they find that there isn't a basis to do so, and then you've got to be back before them for the rest of the case. It's an incredibly poor process.
It's like asking your boss to fire himself.
Yeah, and it just doesn't make any sense. But that's the way the rule works, and for that reason, in some jurisdictions, the suggestion is you don't file such a motion because it raises someone's back, and then they have to explain why it's not the case. But you either do it by letter, and you should not be writing letters to judges generally, but you do it by letter to the court. And that's odd, but sometimes you do. Obviously, you got to give it to the other side. Or you raise the issue first in conference with the judge, which is the better practice, in chambers with all counsel present, and try to feel them out and say, I don't want to file such a motion. But once you raise the issue, it's a delicate matter how you raise it and how you present it. But the the problem is that the person that decides it is that judge. And then you can take an appeal from the order, but it's even worse. And then at the end of the day, you're still likely to be back, because now you're asking the colleagues to say, well, the judge was wrong, judge is biased, or not biased, but their decision, and that's the way people read it, and that is what you're saying, but it's just that their decision would be affected by potentially their prior involvement or knowledge in related matters. But the problem is the process in trying to get that person disqualified, unless you have hard evidence of, some type of corruption or something like that. The fact is that judges have predilections and bias and favorites. I mean, listen, you're going to try cases, criminal cases, representing the defendant, with the judge, in many cases, for many years, was a DA. So are they biased because they have a law enforcement perspective and did for the first 25 years of their career? I mean, one could argue that sounds likely. I mean, well, let's suppose that you have a former cop who became a lawyer, who became a DA, and now she's your judge. And you've got kidnap rape case.
I'll take no.
You what?
I'll take no.
Well, you take what on, though? I mean, is that judge disqualified for bias?
No.
No, frankly, if that's all you got, absolutely no. Right? You don't, what? Because as an advocate and as an employee, I worked for various capacities over time. That's not enough, right? Clearly, and I don't think it should be enough, but it makes me wonder whether that judge can put not and guilty together, right? But that's the way the process works. You've got to have a lot more than that to be able to try and move to disqualify a judge. We got two more cases to do before we get out of here, and it's Thiessen is 2001, and then the Circuit City case. And Thiessen really talks about the class action requirements and the like, which we've already talked about. It also shows you a little bit about this sort of the decertification process that can happen as well, and talks a little bit about EEOC, Equal Employment Opportunity Commission, which is very active and has regulations and various procedures for discrimination cases and the like. And so I think what they ended up doing is sending it back to allow them to try and proceed with an opt-in basis to see if there's plaintiffs that want to join the class who suffered an adverse employment action. I also thought was interesting, it's on page 409 of my book, my decision. It talks about the deposition of defendant's corporate counsel. And believe it or not, sometimes those issues arise, especially in discrimination cases where there's the corporate counsel may have been part of establishing the practices involved or creating the procedure that one would do, say, for requesting accommodations on the Americans with Disability Act or for evaluating employees. And obviously, it should be hard to depose the defendant's attorney, so the court does set up roadblocks in that regard. But it's not impossible. And if you look at the language they talked about here, is that while we don't like it, we think it's rare, but if you can't get it other ways, and it's non-privileged information, then you may be able to do it. It's not something you do as a first resort, it's something you do as a last resort. And the last case we've got for today is the Circuit City case, which talks about the use of these contracts, again, in the employment setting, And I'll tell you, and this is why I like Circuit City for you to think about in this regard. I really do think about this when my son, and this was many, many years ago now, brings home the agreement. He's 16. He couldn't have a clue as to what most of these mean. I don't know how many other people bring that home. Most of the places they bring that agreement to, the two people in the house aren't both lawyers. And the deal is this: you want to work here, sign the agreement, waive your rights, and you can start tomorrow. And this was for a minimum wage position. But the likelihood is there's an awful lot of people required to sign these as part of their conditions of employment who, I need my job, I need to pay my bills, and if that's what I have to do to get it, I'll sign it. Is that voluntary?
Well, it's essentially an adhesion contract, isn't it? I mean,
Is it?
well, you don't.
You have to work at Circuit City?
No, I mean, you don't have to take the employment, but as far as if you got to take the employment, it's not like you get to cross out sections that you disagree.
Oh, yeah,
with.
no, we're not going to negotiate it. No, that's exactly right. No, there's no negotiation. What would you like to change? No.
No, but you have to work, so if everyone's pretty much doing the same agreement, it's unfair bargain.
But, well, it is disparate. It is unfair. But the court doesn't care, do they? So, I mean, is that a legitimate argument? Listen, for $10 an hour, and I need to work, I'll sign what they need. I mean, in this economy, it's tough. So, but that argument doesn't matter. So I waive my rights to go to court. I waive potential statutory claims I might have. And it really doesn't matter that the boss is the boss, and I'm just, this is my first day of eating spit. Sign the agreement.
You can always choose another employment, right?
Well, I know that's what they say, but for a lot of people, it may not be true. And especially now, if you think this was what, 11 years ago. So these cases at the time were sort of cutting edge on it. Now, if you're corporate counsel at Bob's Discount Mart and you see that this is the way it works, you say, hey, we got to have an agreement. We got to limit their rights to go to a jury, cap what they can do, and cap where they can go, and we can make these effective. Is that true?
If it's reasonable.
What do you mean? What does that mean, though, if it's reasonable? Suppose I just say, you guys, all my employees at Bob's Discount Mart, 2-store chain, 5 and 10. No, dollar store. Mike's Dollar Store. 2-store chain. Everyone's going to sign this agreement, and you're going to waive your rights to go to court, waive your rights to a jury trial, arbitrate any claims for whatever reason you may have.
If it was a small place like that, you're gonna have a hard time finding a lawyer to take your case, probably because your damages aren't high enough unless there was enough plaintiffs. But if it was a big place like Circuit City that had an unconscionable or type of situation, and you could prove enough people didn't take the job because of it or something, then enough to get a lawyer.
But suppose that what I was doing was quite egregious, though. Suppose I'm grab-assing the cashiers. And someone suffers significant mental distress as a result of it. You would take that claim, wouldn't you?
Sure.
I would. I don't care whether Bob has 2 stores. So we own a store by the time we're done, right? There's got to be money in it. There's a lot of them everywhere. So, but she's got to go to arbitration? No jury? Because, you really could paint that picture kind of nicely with the jury.
After that case back here, we got some precedent.
So if I get Judge Gartner, I might be able to get past that.
Sexual harassment situation, yeah.
Glad you're not letting it go, though,
If
Cap.
you're a woman, not a man. If you're a man, that might be harder.
No, but you read Circuit City. That could be it. Right? I mean, that's the agreement, right? Whatever claims you may have, you're going to limit the forum you can go to, and we're going to agree that that's where we'll resolve those disputes. And that could be binding. right?
It's reasonable. If it's way
Because you signed it. It's big print. I had you initial it and sign it, along with the other 50 things you agreed to do. And now you're bound by it, even though it was this, or the kids weren't going to eat that week. It was this, or no oil for the oil tank. No, right? But that court doesn't really care. Do they? Right? They don't. They don't care. Because how can you argue otherwise? The employer is always going to have the upper hand, aren't they? I've got more money than you. I'll find someone else to do the job. There's no, for most employees, not a lot of bargaining power there. And if you're some type of superstar, you can bargain whatever you want, but that's not the case for most. So,
Well, is there a presumption that you're not going to get what you want in arbitration?
well, okay, and that's a fair argument, because you won't get what you want. You may get what you're entitled to get, and this is why the defendants want it. But what you won't have is a jury inflamed by the facts come back with a potentially troubling damage award. And that's what they're trying to avoid, right? Those jury verdicts that they hear about that bankrupt the business, which more often than not are a matter of fiction, frankly. Juries are a lot more conservative as a general matter than people give them credit for. But that's a story for another day. I'll see you, well, I won't see you for a couple weeks because you're on vacation next week. Everyone have a safe vacation. Don't get too crazy.
Professor, what section are you on to answer all the questions?
8.
8, okay.
8. You just finished 8. You're going to do 8 with the complaint.
We complain about the complaint?
No, because